What? Hi.
Hi, good afternoon.
Hi, I'm Leah with the Laverne Chamber. You are one of our presenters this afternoon.
I'm Alicia Kennan with Woodsmith, Henning and Berman.
Thank you so much for joining us.
Sure. I'm trying to get positioned so you don't see my Peloton bike in the background here.
Okay. Great. And I did just make you a co-host for the meeting.
Okay.
Good Lord. So that way, and when you are, I should bring up the agenda. When you are giving your presentation, I'll also be making you the spotlight speaker.
Oh, okay.
So people will see just you and not just, you know, the myriad of faces.
Now, are we doing like a round table today? That's what I was told. So
the way we have it set up is each speaker will have 5 to 10 minutes to introduce themselves, kind of talk about what they're seeing specifically within their practice area.
Okay.
How COVID has affected them. And then we go into a Q&A at the end. We've asked everybody to save all their questions till the very end.
Okay.
And if they think about something, they can use the chat function at the beginning.
Okay.
During, here we go.
How many panelists are there total?
I'm gonna say 6.
Okay.
No, we're down to 3.
3.
Oh.
No, both attorneys are just tied up with their deposition today and unable to get out. I just got a word from them.
So is that both the landlord tenant?
No, we have James Blucker, we have Alicia Cannon, and then we have Alex Lester.
So we lost workers' comp and bankruptcy.
Yes.
Okay. Possibly we can lean to Wendy for workers' comp.
Okay.
I could talk a little bit about workers' comp. Very, very narrow. I only defend the 132A claims, which are retaliation claims for filing workers' comp. So I can probably chime in a little there.
Okay.
But not in any level of expertise or detail with respect to the underlying claims whatsoever, except to say the workers' comp appeal board is a nightmare to deal with in general. And it's not anything like regular civil practice at all.
And I haven't heard of workers' comp's claim directly from any of our businesses at this point.
Yeah.
And again, part of this presentation is you don't know what you don't know.
Yeah.
So,
Absolutely.
all right, let me do this.
Hi, Alicia, how are you?
I am just gonna pull something up that I put together, just some notes for today. And since there's a few less of us, I am going to just pull it up so I can even have more stuff to talk about to fill time if necessary.
And again, I think the biggest concern is the automatic supposition that if you are a, oh God, how can I not think of the word that's been used so much? First, a frontline employee, that it's automatically supposed if you get COVID-19, you got it in your workplace.
Yeah.
So I think that's the scary part.
Yeah, and understandably so. I mean, it definitely, I'm definitely, obviously claims take a little while to start developing, but we're definitely seeing claims now arising from allegations that someone was terminated because the other coworkers were afraid that that employee whose husband or wife was an essential worker was going to bring COVID to the office, all the way down to people trying to use COVID as an excuse for a no call, no show that resulted in a termination. So it's definitely coming up. And so, I mean, I think it's a genuine concern for business owners. And then also, obviously, there was a ton of legislation in March and April related to, employment in particular and what employers are required to provide. And I don't know that, people really have a good handle on that. So I did put some information together, just some, bullet points that I can kind of go over with everyone. And I can, like I said, I can spend a little more time if that helps to fill. I know we have 2 hours. So with 2 attorneys who have dropped off, if you need additional content, I can maybe help there.
Thank you. Thank you.
Mm-hmm.
The majority of questions that I've been asked is really in regards to landlord-tenant.
Okay. Unfortunately, I can't help there.
No, and thank goodness we have them on. But the employment is what caught my attention when this whole program and process started. When I was just seeing pages and pages of information about employment law and employer responsibilities, I was like, good Lord, there's no way that our small businesses know all of this. There's no way.
Hi, this is Kevin. Did somebody drop out today?
So 2 of the attorneys, Sabak, Simonian, and Zare Zatikian, they both have depositions that they couldn't get out of. They were working to settle the case last week. It didn't happen, so they went full force. And as of yesterday, they say it took the whole day. Today they were trying to adjust the schedule. They just couldn't do it.
Will they still be able to participate in the externship and creating the white papers with the students, though?
Yes.
Oh.
Alicia, I don't think we've ever met. I'm Kevin Marshall. I'm the Dean of the Law School.
Hi, Kevin. Nice to meet you.
Hello, James. Good to see you.
Nice to see you as well.
Is this James Blucher?
Yes, that's correct.
Okay. I will be making you a co-host so that you are able to share your screen if you are so inclined to do so.
Okay.
Okay. Sorry, I'm using an iPad. That's why you always see my hand and arm going up. I think I saw. Hello, Robin.
Well, obviously this is not Robin. This is Bob, her husband.
Oh. Hi.
But Robin is just walking in the door and we'll be joining together in just a few moments. So hello, everybody.
Hello, hello.
Your video is blank. It just has the name.
Yeah, I kind of figured nobody would want to see me, so I'm waiting until Robin comes in to open the video.
And I see we have Alex Lester now joining us.
Hey, Alex, how are you?
Good. How are you doing?
Well, thank you.
Nice to finally put a face to a name.
Same here.
Hi, Alex, and I've made you a co-host so that you will be able to share your screen if you are so inclined to do so.
Okay. I don't think I will, but thank you.
Hello, Dr. Lieberman, welcome.
Hi, I'm looking forward to this brilliant group of alumni and friends of the University of Laverne and the City of Laverne. We're excited.
For sure.
Oh, goodness.
Hi, James.
Hi, how are you doing?
It's good to see you.
It is. The different times online now.
Well, you got to do what you got to do, and you're
Yep.
doing the right things. This panel, we're excited.
Hello,
Yeah.
Alicia.
Welcome, Councilmember Lau.
Hi. Hi, AK.
Hi, Wendy Lau.
Hi, Wen.
Trustee Lau.
Everyone.
Hi, Robin.
Hi. How are you doing?
Laser focused. That's getting us through this pandemic and well beyond.
Yes. Yes. So the university is doing all online?
We think so. We're still waiting to hear from the city, the LA County tomorrow afternoon.
Oh, good.
Because we want to have, we're going to be virtual, but we want to have labs and like studio art to be face to face. So we need permission for that. And we want to have students living in the residence halls safely. So we want to have permission for that. So we'll hear tomorrow.
Wonderful. Devorah, do we still have a partnership, the university, with Mount San Antonio College?
We do, especially with the business that we have space over there where we're delivering, well, when we're face to face, we're delivering a bachelor, the business major over there for students so they don't have to leave the campus.
Oh, good.
Why?
Well, because my husband, Robert Carter, is running for a board position. Roseanne Bader has resigned, has stepped down. Her term was over. And so she called and asked my husband, she thought he'd be good.
Fantastic.
So
We love Mount Sac.
Bob and I went to school there. He has 5 degrees from there, and I got my accounting degree from there. So
I got my associate's degree at Mount Sac.
good. Yeah, it's a good school, and it's growing and growing. So, and Bob's going to join us too. He's here.
Oh my God. The new board member from Mount Sac. Wow. Sitting right there next to you. The future board member.
We hope so. There is one person running against him. And also Fred Cheer, I talked to him the other day. He's running again for his district. Mount Sac is split up by districts.
Wow.
Okay. Okay, it looks like we're close to everybody that is RSVP'd is logged on right now. I think we are only missing one or two, possibly give it another 2 minutes till 2:05 and then we can get started. Let's see, Jason. And one of our newest board members from the University of Laverne, Lindsay Shiomi, is here.
Hi.
What else do we have here?
A fantastic addition to our board this year. Super happy to have her.
Hi, Deborah. Hi, Wendy. Thought I should at least say hello.
Alva, Jason. Oh, Emma. Well, okay, well, as this is a scheduled long, we shall get started as we have a lot to do. And I am going to start by asking Paul to introduce Dean Kevin Marshall.
All right, welcome everyone. So this has been a great journey of collaboration. But before we even collaborated, we had to be involved and participate. And I think this has been a tremendous effort, both from a standpoint of how the students have collaborated with attorneys and in their discipline, understanding some of the issues that was essential as a COVID-19 impact or as a result of the business community. So I wanted to introduce my dean, Dean Kevin Marshall at the College of Law, to say the introductory remarks. And I think it's just sort of passed down to me, but he was involved initially with this whole project. Dean Marshall.
Thank you, Paul, and thank you, everybody. I really want to convey that the University of Laverne College of Law welcomes this opportunity to serve the Laverne community. This business forum that was brought together by a number of participants and from a number of different directions and stakeholders is really just one of many examples of how our ongoing partnership with the city of Laverne can create value for our respective city and university communities. I want to especially thank Leah Skinner, the Executive Director of the Laverne Chamber of Commerce, and Wendy Lau, Risk Management Lead for AECOM West Region, for seeing both the need and the value of this partnership and how it can create reciprocal value for the College of Law in Laverne. You know, while this was coming together, there was two tracks of this innovative idea. Leah and Wendy were talking to me about the need for our city community businesses to have more information about the complexities that COVID-19 were bringing into the marketplace. And simultaneously, there was a number of students at the College of Law that after COVID-19 starting to have its impact across all the various communities and sections of our economy, came to me and said, we need to do something about protecting and nurturing and serving those who are being impacted by COVID-19. So really these two ideas were simultaneously on track, and then entered Professor Paul Nakashian, who I can't thank enough. Always one who's willing to step up and serve. And he saw that he could play a role and volunteered to play a role to join our students, with the city, and then ultimately with our alumni, so that we could be here today in this virtual space. And so let me finally thank also Attorney Alicia Kenna with Wood, Smith, Henning, and Berman, our College of Law alumni attorneys, James Blucker, Sarera Satikian, Alex Lester, and Savak Simonian, for volunteering and engaging and mentoring and supervising our current law students to put this forum together, designed really to highlight and inform us all on the many issues affecting our local businesses and residences ignited by COVID-19. Clearly, we are hopeful that we can continue this partnership and host future business forums with regard to a host of range of topics that may be of interest to our many community stakeholders. And then finally, I just want to acknowledge my boss who's sitting in the space. This is also a testament of her commitment and conviction to the city of Laverne, the College of Law, and somebody who has really captained these partnerships with a lot of passion and commitment. So thank you all. Thank you, alumni, and particularly thank you, students, because you are the type of student we want at the University of Laverne, one who serves, one who's committed, and one who's proactive. So without any further ado, I'll turn it back over to Paul, and let's get this forum going.
Thank you, Dean Marshall. Thank you for your leadership as well. So this would not have happened today had it not been for the steering committee. Obviously, Wendy Lau, who wears many hats, is an outstanding individual. She just got elected most recently on the city council with the city of Laverne. She's also on the board of trustees, but professionally, she's an attorney with the firm of Wood, Smith, Henning, and Berman, and she has an impeccable resume of experience for the last 16 years in business transaction, contracts, construction, labor, employment, and general liability. So I just want to extend my hats off to you, Wendy, for being instrumental in this process and getting the panel sort of putting it together. Thank you for that. My other member, obviously, with Dean Marshall mentioned, is Leah Skinner with the Chamber of Commerce, who's also been proactive in the whole process, engaging the business community to get us here today. And the two students who are notable in this whole project are Savitri Zala and Nedra Cristobal, who's also part of the whole steering committee. Ms. Zala is a rising 2L student with the College of Law, obviously, and she serves as the vice president for the Student Bar Association. And she just completed a summer internship with the Los Angeles County District Attorney's Office. And she also has another one lined up for the fall with the ACLU. So she aspires to be a lifelong committed to the public interest, to our community, and when she finds time, she's interested in weight training and vegetarian cooking. Savitri, thank you for your participation. The other student who was also part of the whole steering committee is Nedra Cristobal, is also a rising 2L student with the College of Law. She is currently the College of Law's Public Interest Law Foundation chapter president, and it's always looking out, reaching out to expand her sort of devotion to surrounding communities relating to matters of public interest. Her interest is also immigration law and domestic violence law as well. Well, thank you again. So the other students, again, who are been very proactive in doing a lot of the research behind some of the issues that might come up later on in our discussion, I'm going to begin with there's 5 students who participated in this whole process. Akabi Danielian, who worked with attorney Zatikian. She's an undergrad degree from UCLA, Rising 3L with the College of Law. She has a lot of substantive areas that she's interested. Primarily, her interest is criminal law, and she's venturing about this whole transactional law area and torts law. Thank you, Akabi, for being with us today. I also have Esther Levitt, who worked closely with attorney James Blucker. She's also a Rising 3L student with the College of Law, heavily involved with the alternate dispute resolution team, and has a lot of interest in pursuing real estate and family law area. Esther just joined the Journal of Law and Business Ethics in the fall. She's going to be enhancing on her editing and writing skills as well. Thank you, Esther. We have also Rosia Medina. She's also participated in this. She's a Rising 3L student and a graduate of Laverne, undergraduate Laverne, bachelor's degree, and also a College of Law student, obviously. Her interests include immigration, employment, and labor law, and workers' compensation. She also worked with attorney Zatikian as well. Thank you, Ms. Medina, for taking part in this as well. We have next Rodrigo Nieves, who also worked with attorney Alex Lester, is also a Rising 2L student, always passionate about helping out. His interest obviously deals with immigration law. He's also trying to explore his learning experiences with areas of business as well. Thank you, Rodrigo, Mr. Nieves, for joining us. We have also Alicia Rose, also a Rising 2L student with the College of Law. Before coming to College of Law, she was a talent manager and head of business affairs for an entertainment firm. She currently works on nonpartisan activism agency that focuses on voter registration, international relations, and low-income advancements programs. So thank you for the students who took the opportunity to work on these issues with the attorneys, and I think they were very excited by this whole process itself. So moving on to our panelists, our first panelist, I have the name James Blocker. Obviously is no stranger to College of Law. He's an alumnus, and he works for the law office of James Blocker, focusing on corporate counsel work, including real estate negotiations, representations of landlords and tenants, unlawful detainers, business entity formation, and HOA representation as well. So additionally, he assists property managers in guidance through landlord-tenant laws to ensure compliance with the law. Outside of real estate law, he also deals with various aspects of business law and general state planning. As an introductory measure, Mr. Blocker, I just wanted to extend by just very opening general ideas, your thoughts on how COVID-19 has impacted your area of practice. If you could give us some thoughts about that.
Yeah, well, I mean, it's transitioned the practice quite substantially. When prior to COVID-19 happening and the closure of the state in early March, I was in court 3-4 times a week doing unlawful detainers, litigating these cases, settling these cases in court, going to various courthouses. I haven't been inside a courtroom since March 18th. Every eviction has been stopped. No summons can be issued on those since March. Pending cases have been extended through at least October to before they can be heard. So there has been definitely, at least in my business area, there has been a change from actually litigating these and getting tenants out when they don't pay to now working with tenants more and negotiating where the landlord has to take more of a hard look at this is a long-term solution. This could be last months, years. I need to work with my tenants, especially in commercial. Otherwise, I'm gonna have an empty building, and I'd much rather have somebody in there paying me half month's rent right now than as opposed to nothing. So we're working out deals with. So it turned into more just transactional work because all the litigation work has basically stopped relating to landlord-tenant issues right now.
Well, thank you. We're going to open it up for questions coming up, but thank you for that introduction, Mr. Blocker. We're going to move next to Mr. Alex Lester. who also serves as a member of the Board of Trustees for the University of La Verne. He is an attorney with the law offices of Mark John Tunis, and representation includes landlord-tenant relations. Welcome, Mr. Lester. So as an introductory, what are your thoughts on how COVID-19 has impacted
Yes,
your experience from the area of practice and specialty?
yeah, thank you, Paul. You know, in terms of what we do general kind of general civil litigation, a lot of business representation, and contract type stuff, along with employment disputes. And so for us, we've seen, same as James, essentially nothing in court since then, aside from the few criminal cases we handle, where we've had to maybe go do a pretrial or an arraignment. Those, however, are not handled in the courtroom. For example, in Rancho Cucamonga, most things are handled outside. You don't even enter the courthouse. But a lot of what we have done has been to kind of try and continue our litigation process through discovery and really work on our cases so that we can prepare them for whatever the next hearing coming up may be. We have, you know, a few trials that have been continued, and things are getting processed that way, I suppose you could say. But yeah, from a standpoint of what it means for businesses, really it hasn't, at least in our eyes, changed a whole lot for the litigation that we currently have. The one thing that has changed, I think, is we have a lot of business clients who are questioning whether or not they can even continue to operate, and whether or not they'll be viable as a successful business when things begin to open up more fully. And so, you know, hopefully we can help answer some of those questions, but it has caused a lot of owners to be hesitant to seek advice or anything like that, just from a pure, you know, return on investment or cost standpoint. You know, if they're not operating their business, they may not be able to afford seeking legal counsel in most instances.
Thank you, Mr. Lester. Moving on to our third panelist, I just want to mention Zareh Zatikian and Savak Simonian. We're going to join us. I'm hoping that they will, but they're still stuck in deposition today. They tried to settle their cases yesterday to be part of this whole panel, but it looks like it's very slim that they will. But in any event, I want to introduce our next panelist, Alicia Kennan, attorney with Wood, Smith, Hennig, and Berman. She specializes in the litigation of claims involving employment practices, professional liability, securities, financial institutions, and construction, both in context of defect and catastrophic personal injury. Ms. Cannon is a fierce advocate for individual, public, and private clients facing allegations of unfair employment practices, negligence, and product liability.
Thank you. I appreciate you guys giving me the opportunity to join today. Special thanks and shout out to Wendy Lau. We were partners and colleagues together at Woodsmith, Hennig, and Berman for nearly a decade. And so I appreciate the opportunity to join this panel this afternoon and share some of the things that I've been seeing in my employment practice in particular with respect to the coronavirus. Obviously, at the start of all of this, back in March, much like the other two attorneys have mentioned, you know, I was in court actually arguing a motion, and within an hour of completing my oral argument, everything in the world shut down. So, you know, there is a lot going on out there, and within a few days of that, there was a lot of legislation that was issued during March and early April. And since then, we are now starting to see the claims arising from various types of violations of the new legislation, as well as old traditional California employment law under Fair Employment and Housing, et cetera. So there's definitely been a change. Most employers really don't have a good grasp on what the FFCRA, which is the Families First Coronavirus Response Act, or the CARES Act, how it might affect them, what they're required to do for their employees, and how in general they're supposed to deal with COVID in the workplace. So happy to share my thoughts as this afternoon progresses on those issues that I'm seeing.
Thank you. Thank you. Welcome to the panel. I think at this time we're going to open it up for question and answer session with Leah Skinner. And we also have students who also have questions they are going to propose as well. But I want to turn it over to Leah for questions from the audience or the business community.
Okay, here we go. If you have a question, if you want to use the chat function, then I'll be able to call on you using that. I was emailed a question before the panel started, and it was regarding a landlord-tenant issue. A landlord with not non-payment, but a for-cause reason to evict the tenant. And specifically, it's about an over occupancy issue. So the landlord could also potentially be penalized. What do we expect to see from the paperwork that they filed on that?
Okay, yeah, I can take that. So I'm assuming this is in the County of Los Angeles, and
Correct.
with the County of Los Angeles, they have their own specific moratorium. So this is where we're getting calls daily, and people are confused because they hear on the news the moratorium ended. That was a federal moratorium that ended as of July 31st. However, the state of California had their own moratoriums. The N3720 executive order N3720 extended until May 31st. And the governor did not extend that, but he allowed local jurisdictions to extend until September 30th. So Los Angeles County is one of those counties that extended their local moratorium through September 30th. As part of that in there, there is specifics of no summons can be issued, so no complaints can be filed on eviction for any reason, COVID related, non-COVID related. Really the only exception is if there is causing a nuisance or danger to the surrounding area. And that is very hard to actually meet that threshold because it's not defined. I was talking to another attorney that specializes in landlord tenant in Los Angeles, and an apartment complex there tried to evict somebody because one of their family members shot and killed somebody, or somebody in the apartment shot and killed somebody. So they went and filed this emergency order to get a summons issued. And the judge, before you can get a summons issued, you have to file ex parte to go in to show that this is a needed requirement. And the judge found in that case that, well, he was arrested, so it's no longer an emergency because he will not be coming out and he'll be tried for murder. So no, you have to wait until after this eviction moratorium is over and cases can proceed forward. That includes also County of Los Angeles specifically has in there that you cannot file an eviction right now or serve a tenant for reasons of over occupancy. So if the state of California put this stay-at-home order in effect, and if there are people during this moratorium period that are staying in the property that are not subject to the lease, there's really not much a landlord can do right now. The County of Los Angeles moratorium goes until September 30th, but it can be extended on a month-to-month basis if the governor approves so.
So I have a follow-up question on that, Mr. Blecker, as to the extent in which if landlords are not collecting or unable to essentially collect the rent, to what extent those can be recouped in the future, or that is kind of out there, has not been really explored. It just feels to me as though I'm one of them, for example. I have tenants who haven't paid rent for the last 4 months. The bills are piling up, and their inability to pay or lack of commitment to pay, defaulting on their obligation under the lease, to what extent those could be recouped in the future, or is there any guidance on that?
Yes, no, there definitely is. There's been no law that passed that said rent is waived. In commercial tenancies, the California legislature was trying to adopt a law that said that in commercial, if you have a specific type of business where their income decreased 50%, then you could decrease the rent 50%. That did not pass and is not the law. So the way the law is written right now is all the rent due, if you deferred it and you haven't paid, once this moratorium's over, you have to pay it back. Now, the County of Los Angeles has one of the longer periods in there, and of 12 months. So if this moratorium ends September 30th, then starting October 1st, the rent is due, the normal rent is due, and then if you had to defer $10,000, you would have to pay that $10,000 back over a 12-month period. So a landlord cannot initiate an eviction based off of that back due rent that's owed, so long as the tenant remains current. Now, that's the way that the County of Los Angeles has it right now. Other counties do not have that, do not have a specific time period. There are certain cities that have it. The City of Ontario has a 6-month time period, and you just have to look city by city. Again, I wouldn't be surprised if this is something that the California legislators passed, of doing a uniform type of, okay, any rent that was deferred during a moratorium period, a landlord must work in good faith with the tenant over a specific time period to pay back. And the County of Los Angeles is one of them. That is a template that they could follow of, as long as you remain current on your then current rent, you would have up to 12 months to pay back if it's residential or commercial with less than 9 employees. If it's more than 9 employees, then I believe it is 6 months.
Thank you, Mr. Lucker. Mr. Lester, do you have any additional comments on the matter, on the subject of the question?
No, I don't think the only question I had, but I believe Mr. Glucker answered it, was in terms of the difference between residential and commercial issues in terms of filing and acting on unlawful detainers. But I believe he sounds like they are the same, at least in Los Angeles County.
And in fact, the Judicial Council has a rule in effect so that says no summons can be issued on any type of eviction until 90 days after the state of emergency is declared over. That we're in a state of emergency right now, so when clients are calling me, well, when can I start an eviction? If it ended today, in November maybe. However, as of 10 minutes prior to entering into this, the Judicial Council did meet and they repealed that order and said that now no summons can be issued until September of next month. So it's starting to look like they're starting to open it up, and their rationale behind that was, we're not the legislative body, we're not approved to make laws. We did this temporarily to give the legislator time to create their own laws. And since they haven't done anything, we're not going to keep holding this temporary prohibition against filing unlawful detainers and not issuing summons. So they're going to start allowing it as of September 1st to start issuing summons and having evictions to go forward if your county is not in. So Los Angeles County still has a September 30th moratorium, but in San Bernardino County, they could potentially go forward as early as September 1st. If there is no California legislation that passed. When the Judicial Council first announced 2 weeks ago that they were discussing repealing this, the legislators came out and proposed a law that was identical to the Judicial Council of no evictions until 90 days after the state of emergency is declared over, or April of 2021, whichever date happens first. That is in debate. It hasn't passed. So as it stands right now, September 1st in certain counties, and after the moratorium ends in LA County, after September 30th, then an action can be filed. But that could change with the ever-changing laws in California.
Thank you. Thank you.
I am not seeing any questions in the chat function, so it is open question and answer time right now. If you have any, not specific to any individual lawsuit. Okay. I just got a question. Is it overstepping as a landlord to ask tenants if they received EIDL or PPP loan and to require tenants to use these funding sources to pay back rent?
I guess I could take that one too. You definitely, part of all the laws that required for COVID related deferral was supposed to be you have a substantial loss of income, and that is also substantiated with documentation. And when the executive order first passed, evictions were still allowed to go forward if you didn't have a substantial loss of income or if you did not provide that documentation to your landlord within a specific time. However, then shortly after, that's when the Judicial Council came out and said, in light of the stay-at-home order, we're going to stop all evictions, and nothing can go forward. So then it transformed into COVID-related only reasons to any reason. So you can't evict any tenant for non-COVID related or not. And that's where it's coming up. As far as asking, when we would send out deferral programs and try to get people on payment plans, we would always ask, did you get any paycheck protection? Are you filing unemployment? And those are acceptable questions. However, there was a landlord that an apartment complex owner in the city of Los Angeles that was sued because they were making them sign a requirement sign that said your unemployment must be sent to me, or your extra $600 or your stimulus check must be given to me as part of it. And then that's when the taxes came out and they passed stuff that you said you cannot make this contingent upon it. The only requirement is that for COVID related defenses is you have to show that you've had a substantial loss of income and you have documentation to prove that.
Have there been any talks about what recourses the landlords have if the tenant decides to move out of the area?
I mean, if they decide to move out of the area, you could still always bring it. If they move and they owe you $10,000, $12,000, $15,000, you could always bring a civil action against them. However, what I'm advising, when I do evictions, there was a statistic that said about 90% of the judgments you get are never collected upon, especially in residential matters where these tenants don't have a whole lot of assets. You're going to get a judgment that you might attach, do an abstract judgment, but for the most part, they're never collected on because they don't have a whole lot of assets. From what I predict is next year, when these start coming through and you have the tenants that have been ignoring since March or April, I predict next year will be the year of bankruptcies. They're gonna milk it out to where they're gonna be staying in, if it's an apartment complex or a residential unit. I get calls every day of landlords saying my tenant stopped talking to me in March, hasn't paid me since March. They're gonna try to milk this out to where they'll be there till the end of the year, early next year, owe $20,000, $30,000 in rent and file bankruptcy. That is kind of what I've been talking with other attorneys that we foresee is happening, because all these people are getting so far behind. There's no specific law that says a landlord must waive the rent. So these landlords that are going to be aggressive and going after them, they can, but they just might get a bankruptcy. Or at that point, it's the throwing good money after bad money. If you're already down $8,000, $10,000, do you want to now pursue litigation and get a judgment against somebody you know that probably you will not be able to collect on? So there is no specific way to go after them if they leave the state. I mean, if you have an application on them, you have their driver's license, you have their social security number, you should be able to find them through some means. It's just collecting on them will be the tough part.
The year of litigation into the year of bankruptcy.
Okay, so do we have any questions regarding employment-related issues to involve our third panelist, Ms. Alicia Can?
Ooh.
How about from the team, from the students? Do you have a couple questions as well?
I have a question.
Yes.
In looking ahead at some of the employment liability practices, will someone with a compromised immune system later qualify for benefits, or I don't know what the right word is, leniency at work as part of ADA?
And I think that's a question that's very specific to each person's claim. Under the ADA, employers are required to provide a reasonable accommodation so long as with such an accommodation, the employee can perform the essential functions of their job. I think what you're going to see is, in terms of leniency with respect to protected leave for treatment for things arising from COVID or related to COVID, I think you're going to see the courts being a little more lenient on things like that. But, you know, to answer your question specifically, I don't think that benefits are going to somehow be denied as a result of someone having, you know, an immune compromised situation either arising from or related to COVID. But you're definitely going to see an uptick in people claiming that COVID or COVID-related complications or COVID in the family or just COVID in the universe in general justifies, you know, them not coming to work or not reporting, you know.
But what's an employer? So what is an employer to do?
I mean, that's the $1,000,000 question, isn't it? What is an employer to do in any employment case? You've got to document what's going on. If somebody comes into you or doesn't show up for work, I mean, it's incumbent upon you as the employer to say, you know, we have this policy in place, 2 no call, no shows is grounds for termination. You are going to be terminated effective, you know, end of day today if you do not provide some documentation with respect to where you have been. So it's going to be all about the documentation. I have literally right now in the last week gotten 2 COVID discrimination-based claims. One exactly in the situation that I've described, where the employee had 2 no call, no shows at a restaurant. And then they gave him one more chance, which is always the kicker there. And the employee no called, no showed again. He was terminated. 6 days later, he sends them a text message with a screenshot of his COVID test results saying, oh, the reason I didn't come in was because of COVID. I was exposed and I needed to get a test. Well, you need to communicate that as an employee ahead of time. It's not going to be sufficient that you bring that information up after the fact. But again, just like with any employment claim, if you haven't documented it, it did not happen from a defense standpoint, right? Plaintiffs get away with a lot more with respect to that type of stuff, but absolutely, you're going to have to keep it documented.
Okay. And one last question.
Yeah.
What is the overall opinion of providing or protecting businesses from liability related to COVID? I know that's on a federal level, but will there do something state?
And just to clarify your question, do you mean what are employers obligated to do to protect other employees from COVID? Or did I not understand?
Overall, you know, on the federal level, there's a push for business liability immunity.
Right. Okay, so the state of Nevada actually just came out with laws creating some immunities for liability arising from COVID exposure at work. I don't know if California is going to do that, but certainly even if it didn't, there would be the typical defenses that would come into play in terms of exposure. That would be a workers' comp type claim, and I don't do workers' comp. But as a matter of course, if you're injured within the course and scope of your employment or become ill within the course and scope of your employment, that's going to fall under a workers' comp liability situation. And absent a finding that something the employer did enhanced, increased, or intentionally caused a greater risk to the employee, there's not going to be liability outside of the workers' comp world.
Thank you.
Sure.
Oh, is he tatted? He's tatted?
Hello?
Was he on days or nights? David Raya?
I'm sorry, did someone have a question?
There's a question in the chat, Leah.
Yes. Oh, there's 2 of them actually. Oh, there's several of them actually.
Okay.
Okay. What are the responsibilities, if any, of commercial landlords or property management companies in regard to tenants or tenants' patrons contracting COVID-19 on the property?
I mean, I don't know that question's really for me because I don't do landlord tenant, but I would think it would be the same as, employer situations.
Yeah, as far as buildings go, it's landlords have put in signage, 6 feet distancing. They follow the CDC guidelines and BOMA guidelines, which is Building Operation Management. It's a big alliance in California. They've kind of put out standards So as far as commercial tenants go, I've advised most commercial landlords, property management companies to put up signage when you first enter into the premises of do not enter the premises if you're having any XYZ symptoms. 6 feet apart, stickers everywhere, elevators on each floor. And then as far as besides that, if a tenant reaches out to a landlord and says that there has been an employee that has encountered COVID and has actually had COVID, then I advise the landlord to send out a letter to that building and to say somebody's been impacted by COVID and and the landlord has been taking additional steps and has janitorial coming in and thoroughly cleaning the common areas. The issue with these tests are it takes a while to get the results back. So a lot of times landlords have been tenants have contacted landlords and said, FYI, we just found out a tenant had, or one of our employees had COVID. The last time they were in the building though was 2 weeks ago. Do you still have to notify the building? Since it's within that 14-day period, I normally say if you find out that somebody's had COVID in a building or a suite within 14 days, then send out a letter to the tenants and just advise that extra janitorial will be thoroughly cleaning the common areas. And then besides that, as long as landlords put up signage at the front doors, elevators to do not enter if you're having symptoms and stay 6 feet apart, then they're doing their part that they're supposed to do.
So my apologies, my internet keeps dropping me, so I just went into my phone. So I have another question for Alicia. So what are some of the frameworks or the parameters under which that companies comply with wage and hour laws when employees are working remotely? What are some of the framework under which that it's impacting the wage and hour laws when we have employees who are working remotely?
Right. I mean, I think one of the things that I would say is that my advice to people working remotely is very similar to what it would have been if you were working in the office, or in a, again, working remotely has an assumption built into it that you are, an office worker as opposed to working in a restaurant or something. So here's what I would say pre-COVID, and here's what I would say during COVID, is you need to have a policy, procedure, or protocol in place for how and when your employees are to report to work and what they are supposed to report and how you are going to track it. So just like before, if someone's required to clock in by a certain time, then the expectation is that you enforce that same clock in, clock out. I would discourage people and employers from allowing their employees to sort of willy-nilly come and go and work as they please. Have a scheduled work day. Certainly there could be some staggering there because there are certain things that people are going to need to accommodate at home that are going to be a little more challenging, such as distance learning and maybe caring for a child who can't go to daycare or something like that. There's certainly going to be some flexibility within there, but as a general measure, you should have a start to your workday and an end to your workday. Reiteration regularly about what your break and your rest break and your meal break policies are, and some sort of mechanism of enforcement. I was speaking with someone today before this call. They utilize ADP. A lot of people really rely, a lot of employers, especially smaller businesses, really rely on their payroll provider for a lot of information. And one thing she told me that I was very concerned about was ADP had this option where if someone works more than a certain number of hours, they automatically clock you out for a lunch break. Well, that's great in the sense that the person's automatically clocked out. It's terrible if you're trying to establish that you didn't, as the employer, shave their hours or adjust hours in some way that you weren't supposed to. And so I recommended that they take that feature off and put the burden back on the employee to clock in and clock out as they are required to per their company policy. And then at each interval, before payroll is issued, your payroll manager, your HR person is looking at that and saying, oh, I see that Alicia didn't clock out for her lunch this week. Let me send her an email and say, on X day, you failed to clock out for lunch. Per company policy, you're required to clock out. Please confirm in writing that you took a lunch break that day and what those hours were. So putting it back on the employee to provide that information so that you as the employer have the record of everything that you did to try to enforce the wage and hour laws with respect to that. Now, obviously you cannot control whether or not people log in, after hours, but I do know that there are options that your, IT departments and people can implement that don't allow hourly employees to log into the system after a certain number of hours, say after 5:30 p.m. So there are definitely ways out there to do it. And I think, there are opportunities for diligent employers to really rein in any potential claim that relates to wage hour violations during this time. You actually have a little more control over it than you probably did when they were working in the office.
So let me ask a question to Alex Lester. I know you brought up the whole issue between the commercial tenant as opposed to a residential. Is there any layers to that? Is there anything that is sector specific about the non-payment of rent or the obligation under the contract or partial payment? Are they any sector specific measures, or it's across the board the same obligation, commercial, residential, sector specific? Is there?
Unfortunately, that was why I asked. We don't do a lot of landlord tenant, so I was curious for what James had to say in the sense that that's mostly or seems to be mostly what he practices. We initially were under the impression that commercial businesses, or at least commercial evictions, were not subject to the same limitations as residential in terms of whether or not unlawful detainers and summons would issue and evictions would go forward. But I believe, again, as James pointed out, that those rules have changed, and it sounds like they will essentially mirror each other at least through the end of September.
Okay, right, thanks. So going back to Alicia, I had another question that I just wanted to just sort of provide some measure of, I don't know if it's possible to have a consistency, but how do you implement? You have a lot of new regulations and new standards coming up. From a standpoint of an employer and implementing CDC or EEOC guidelines and state and local public health protocols, how do you measure or find a way or navigate through these inconsistencies between various governmental authorities?
I mean, there is a lot of inconsistent information out there. Again, I think you want to take, as very commonly repeated in nearly every course you take in law school, the reasonably prudent employer under same or similar circumstances. You need to be taking, you maybe don't need to take the utmost precautions, but you certainly need to be taking at least what everyone is articulating consistently as minimum precautions. Face masks, social distancing, and also you need to take into account what your particular business can handle in terms of accommodating that. So I don't know that there's one answer or that there's even any answer to that. I just think that in terms of operational guidelines, operational enforcement, those are going to be key issues that, as a defense attorney, if a year from now I'm presented with a case that, is an allegation that the employer didn't take appropriate action to prevent the spread of the coronavirus in my office, yet I was required to come into work, I think then what I'm going to want to be saying, and I'm going to want my future client to have documented, is, hey, we have this policy. It is, you must wear a mask. You must notify the office manager when you are coming in. We are taking temperatures. We are providing and did provide, as we were required under the FFCRA, the emergency paid sick leave for anyone who either had a diagnosis of COVID or were concerned that they had been exposed to someone with COVID. So we did everything that we could to mitigate against that risk. And unfortunately, we can't eliminate all risk. And that is, that's true in the world in general. So I think those are the kinds of things that I'm going to want to see in a file, documented in some way, shape, or form, and that those things are reiterated. I mean, we're in month 5 now of sheltering in place in California to varying degrees by county. But the reality is, those policies need to be repeated and enforced often. You can't just let the fact that we're now 5 months into this and the whole world seems to have gotten far more relaxed about mask wearing and social distancing, et cetera. As the employer, you're the parent basically, and you need to sort of keep people in line when it comes to that. So that's what I'll be looking for.
Thank you. So I think my next question is to James and Alex. If you could provide any sort of a interpretation as to how are we doing on the force majeure clauses in a contract, to the extent in which, how is that being interpreted, given the nature, traditionally act of God could be a sort of a significant factor. How is COVID-19 being interpreted in context of those clauses in a contract, contractually? If you could shed light on that.
Well, I mean, at this point, there has not been any litigation on that, especially with courts being closed. A lot of, in at least California, the standard commercial leases and AR lease, and there's actually no language on force majeure in there that would allow to go forward. There's been some.
Can you tell us what that is, so that the spectators could understand what does a clause do as in context?
Yeah, and like an act of God that would prevent you from having to, well, in this case, pay rent. That the COVID happened, it shut down our businesses, therefore we're relieved of paying rent. The landlord's position is that this is not an falls under the lease, and your obligation to pay rent continues. You have the space. You do as you wish with it. I haven't really seen any litigation to that point yet. I have read an article or one case on a bankruptcy that came out of Illinois that said that was a filing bankruptcy, and they used this force majeure clause, and with everything in there, they reduced the lease term by, I think, like 50%, the value of it, 50% of what was owed. But I haven't seen a whole lot of, I see that tenants always arguing, well, force majeure, I can't operate. And then that's when they say, well, the building was still there. You still had your space. You agreed to rent the space and you use it as you wish. And so it's not our responsibility if it's closed. Like I said before, reasonable landlords are working with tenants because they don't want a vacancy at their property. And then it just depends on, with commercial leases, each one is different. So it depends on what they actually have in there. For instance, one landlord called me up and said that I have a small tenant in a commercial shopping center that's not paying, and he says he doesn't have to pay. Is that the law? And instinctively you say, well, no, the law is, even if rent is not waived, it can be deferred, but let me see your lease. So then I looked at his lease, and he had this provision in his lease that said co-tenancy, that he does not have to pay rent if the major co-tenant, if at least 50% of the building is shut down. Well, he was in with all these, it's a commercial shopping center where more than 50% was shut down. And then I looked at his lease and said, under your case, yes, this tenant does not have to pay. But it hasn't gone through the courts yet on this force majeure, which will probably be coming next year once these cases start going, for the landlords that are aggressively going after their tenants for this and not working in good faith on the payment plan. That will be the tenant's defense as force majeure, and it will really depend on how courts interpret that.
Thanks, James. Anything to add, Sylvester?
Yeah, I agree with what James said. I think from a commercial lease standpoint, it's really going to depend, as he said, on what the contract says. There's LA County guidelines are saying, for example, that any indoor mall has to be closed to business, and they define an indoor mall as a building that has, I believe it's 7 businesses that you can then shop inside. So if the provisions in the contract would require or would allow you to not have to pay rent because the other businesses are closed, then if you were in an indoor mall in that sense, then you would be able to use that. However, whether this is an act of God or whether or not you're going to be able to get out of other types of commercial contracts, say the delivery of goods or some kind of service contract that you have with someone. We don't know yet, whether it's good or bad. The litigation hasn't really come forward on that issue yet. I think where there's a business that is determined to be non-essential and not allowed to open, you're going to find that courts will probably say, even though it may not be an act of God, this business couldn't perform its duties and therefore couldn't act according to the contract, and so they're going to be let out of that. Again, though, without those cases having been decided yet, we just don't know. So it's really going to be a very circumstantial type of a case where we have to look at everything that was happening, all the different facts, and make that determination very individually.
Thank you, Mr. Lester. A question for Alicia again. So I know that we had situations and circumstance. We heard from Mayor of the City of Los Angeles, Garcetti, saying in the past that snitching pays, right? It's a measure under which that we have to control this health measure. So how is that extended to? What is some of the criteria or from a labor standpoint or employment standpoints, from an employee to employee? Snitching on another employee, not following social distancing measure or wearing a mask. What are some of the rights and obligations in that setting?
Again, I mean, when you're working for an employer, there is a certain amount of control that employer has over what happens within the four corners of that employment. And that includes setting up, health and safety requirements within that environment that an employee is obligated to follow. So if you have a person who thinks the whole coronavirus is a hoax and refuses to wear a mask, you're going to be able to take action against that employee, unless of course they assert that the reason that they aren't going to wear a mask is because of some protected category or some disability, in which case you're going to have to figure out how to accommodate that. So it's all going to come down to what is the most reasonable path forward here. So let's say in my hypothetical that the employee claims that they have asthma that prevents them from being able to wear a mask. Well, then you as the employer, you're going to need to analyze whether there's an accommodation that you need to provide for that person. Maybe that person needs to be permitted to work from home. Maybe that person needs to be permitted to work a different shift that is, less busy. Maybe that person's workspace needs to be moved or contained in some way, shape, or form. It's going to be all about what's reasonable under the circumstances. And again, as the employer, you're going to want to act reasonably and not rashly, and not get into, long protracted arguments about whether an employee should wear a mask or not wear a mask. Now, if you have a coworker who's reporting that, Sally's not wearing her mask and I feel unsafe, just like you would have to do in any kind of hostile type working environment claim, you're going to have to investigate that and find a solution to it. Again, it might involve moving someone to a different shift, moving their workspace, and it could even involve disciplinary action. I mean, PPE is not new to the workforce, right? I mean, it's new to the world in general, having to wear it all the time. But, employers can require the use of personal protective equipment. And if it becomes necessary, and for many places it might, you might start seeing PPE policies for employers who traditionally didn't need them. And again, it's just going to be a matter of enforcement, consistency, and documentation.
Yeah, so as a follow-up question, if I am fearful that this particular employee is not wearing a mask and I'm fearful of getting COVID-19, do I have the right to stay home and refuse to come to work and still hold my job and not be terminated? If I am, could I have a claim against the employer and file an EEOC claim and so on and so forth? So
yeah, I mean, again, it's going to depend on whether you are reasonably in fear of contracting COVID-19 as a result of that, right? So it's going to be the same thing. And the same analysis is going to come into play. We're going to look at all of the factors. What was the employer doing to enforce the PPE requirement? Was there a report regarding this particular employee? What did the employer do in response to address it? Did they come up with an alternative work schedule or an alternative work environment that allowed you to feel protected? Now, if you're unreasonable, just like if you were unreasonable about anything else in the employment context when you're looking for an accommodation, that is going to be your downfall as an employee. I have a case right now where a woman is pregnant. She is a truck driver. Her doctor imposes restrictions that says she cannot lift, pull, push, or carry more than 25 pounds. And she cannot, and this was very specific, cannot put chains on the commercial motor vehicle. Well, I mean, she's driving over the pass between Sacramento and Nevada in the winter. It might snow. You might need to put chains on. She wanted an office job. Well, the law does not require an employer to create a job for an employee that needs an accommodation. The accommodation that you're requesting must be reasonable. And if you, with or without a reasonable accommodation, cannot perform the essential functions of your job, your employer is under no obligation to keep you. So again, it will depend on how legitimate the concern is for the contraction of the coronavirus. But again, we're going to be doing this reasonableness analysis just like we would with any kind of ADA claim.
Thank you. Go ahead.
I have a question that was sent to me privately, related specifically to the force majeure clauses in contracts and the construction industry, and whether or not such a clause is going to, I guess, allow a construction company to deliver a finished product, if you will, later than anticipated. The way I would look at that, again, under the such a force majeure clause is, construction is considered an essential business right now. So it's probably not going to be looked at as you can't do your job, you can't finish your project, unless you can document with number of employees or workers or whatever you can. And as Alicia has said numerous times, documentation, of course, is key in being able to prove any type of case, employment cases and this type of stuff, definitely, especially. But if you can prove that because of physical distancing and social distancing and the requirement of masks and keeping people apart, that is what has caused you to delay completion of a construction project, then again, although I don't know that it's necessarily the force majeure clause, I think that there is an argument to be made and potentially some safety net for you in terms of not being able to deliver on time for valid reasons under this current coronavirus pandemic.
Great, thank you, Lester, for that additional observation. So, Alicia, I'm going to go back to you again. Maybe you answered this, and I don't want to be redundant. However, let's assume that the employee still believes reasonably that they're going to get COVID, and they don't want to come back to work.
Yeah.
Right? So, can they claim sick pay, leave of absence, any number of situations that could justify their reasonableness to essentially dictate some of the outcomes?
Sure.
Right? Sick pay, for example, leave of absence, reasonable accommodations.
Yeah, so let's talk about each of those in their own right. First of all, under the FFCRA, which is the Family First Coronavirus Response Act, there is an emergency sick leave provision within the FFCRA that provides employees with 2 weeks of paid sick leave to either care for themselves, care for, a family member, or if they've been ordered to quarantine because of coronavirus. it does not extend so far insofar as you're just afraid that you're going to get corona, so you don't want to go to work. But certainly, again, I'm going to sound like a broken record by the time this is over, the number of times I'm going to say reasonable. If your employee comes to you with that, you're going to want to say, okay, well, we can give you, these 2 weeks of sick leave per the FFCRA. You can take that, and hopefully 2 weeks from now, you'll be feeling more comfortable with it. You're going to next look at the Family Medical Leave Act, FMLA, under federal law, and see, does the person qualify for medical leave, protected medical leave? Are they caring for someone that has corona? Are they, immunocompromised themselves such that they need to isolate or, I don't want to go so far as to say quarantine, but just protect themselves a little more than the average person. And you're going to determine whether they qualify for that and whether you're going to be able to accommodate that. You're going to look at the ADA requirements and FEHA and determine whether you need to accommodate their condition. Let's just assume that they have some sort of condition that requires them to take extra precautions with respect to corona. There are a number of things out there that can and should be considered. And again, as the employer, you want to take that into consideration. And again, document things, be consistent, and create policies, provide the opportunities. But you also, as an employer, really need to be careful, because there are people out there that are just going to be opportunists about this. And they're going to say, oh, I'm very afraid of coronavirus, so I don't want to go to work and you still need to pay me. That's just simply not true. There's the analysis when these cases are litigated are going to be analyzed, I would say, exactly as we've litigated and analyzed any other ADA type claim or protected medical leave claim. And certainly anyone can go on a leave of absence that's afraid and come, if your job is still there when you want to come back a year from now and the employer wants to hire you, that's certainly an option as well.
I have a question, Alicia. The emergency paid sick, is that exclusive of sick leave that's already offered by your employer?
It is. It's an additional sick leave that's provided under the FFCRA. So it's an additional 2 weeks that must be provided. So it goes to full-time employees up to 80 hours, and part-time employees are eligible for 2 weeks of pay of their regularly scheduled hours. So if it's a 20-hour-a-week employee, they'd be entitled to up to 40 hours. And there's dollar maximums on that as well. But, we can get into the specifics of those, but it's basically, unless you're making over $70 an hour, you're not going to hit that maximum dollar amount in 2 weeks. So,
Alicia, I have a question for you. This is
Yeah.
Robin Carter. Going along with what you're talking about, what if the employee, after coronavirus is calmed down more, what if they just say, you know what, I've been able to do my job from home and I'd like to continue that way, and I don't see why I can't do that. What does the employer have the right to say, nope, I want you back in the office?
Yeah, they do.
They do.
Yeah, you can force people to come back to the office. This was, this is a temporary thing for most people. And if you did not previously have a policy or an opportunity for people to work remotely, then you absolutely can require them to be back in the office. I mean, speaking from in our own office, our legal assistants have always been office employees. Attorneys have always had a lot more flexibility in terms of, by nature, obviously, we're out in the world, we're going to mediations, depositions, we're in court. So there's a lot more in and out of the office for us. But, when the time comes and it's safe for everyone to be back, everybody will be back.
Any other questions to the panelists?
Paul, there are 2 more in the chat function.
Okay.
I think you covered a little bit of this, but With most K through 12 schools going forward with online distance learning, how should employers handle situations where employees have to stay home to watch over their children?
Again, there's under the FFCRA, they can utilize 2 weeks of the emergency sick leave. Through negotiation with their employer, they can use it intermittently. But again, you know, it's just really tough for the average, let's say 9 to 5 employee to work and oversee either children who are not school age or oversee distance learning for their children. And so what I would recommend to employers, again, is to try to work with your employee as much as you can. Even though you're not obligated to do anything, if they're a solid employee, then, you know, talk to that employee about creating an alternative work schedule for them. Maybe they work, you know, from 6 in the morning until 9 in the morning. And then once they get the kids set up with the distance learning, they can, you know, take a break, say from 9 to 11, and then they come back for a few hours in the afternoon, and then another break, and then maybe another few hours, you know, in the evening after normal time. So that would be the only situation where I'm sort of contradicting myself about what I said earlier in the day about setting, you know, to avoid wage hour violations, setting up start and end times. I think it's fair to take that into consideration. And the reality is, though, there are some businesses that aren't going to be able to do that. And while it's unfortunate, it's not discriminatory. It's not illegal to let someone go because of something like that. It's not, you know, the most humane thing to do, but sometimes these things happen. And it's unfortunate, but there's no requirement. So it's just a matter of what you're able to do as an employer, who you can work with.
So we have another question from the participants. What is the current status of Assembly Bill 5, AB 5? This was a big deal for a lot of small businesses prior to the pandemic. Is there any reprieve for businesses that were in the middle of moving independent contractors to employees due to the pandemic? My guess is no, but just wanted to ask.
Yeah, I mean, I would say no, although I'm sure everyone heard on the news yesterday that Uber came out and said if AB 5 isn't repealed, essentially he's going to stop Uber service in the state of California. I assume
what AB 5 is first, please.
Yeah, AB 5 is the new law that basically eliminates gig workers, the gig economy. It essentially says, and I'm going to really distill it down to about 2 sentences, is there's no such thing as an independent contractor in the state of California anymore. If somebody works for you, they're your employee, period. And attendant to having an employee means you pay employment taxes for them. You provide, you know, minimum essential benefits as required under the Affordable Care Act. You provide sick leave. You provide, you know, all of this typical required things for an employee. And with the exception, again, and I'm probably overstating the breadth and the depth of the legislation a little bit, but honestly, practically, the only entity that's been able to sort of retain independent contractor status are realtors. They have a really great lobbying platform that's enabled them to keep that. But for the most part, if an employer calls me and says, and I had this call this week too, hey, we're starting a new business. I want to hire this person just sort of temporary. Can I just 1099 them and hire them as an independent contractor? You definitely can, but you're probably going to get sued if things ever go bad, because it's almost it's just not a thing that you can accomplish in the state of California anymore. It's a fallacy that an independent contractor even really exists.
So I have a follow-up question from the participant as well. What if the independent contractor contractor lives in California, but the business is registered in, let's say, Nevada or Alabama, another state, where would AB 5 be in that setting?
I mean, if the law, where you earn the money is the law that applies to you, right? So it doesn't matter that you're working for a company that is in Nevada or New York or Alabama for that matter. That company is required to comply with the laws of the state of California. And if the laws of the state of California do not allow for an independent contractor, and a lawsuit is brought in the state of California arising from the employment relationship, whatever that may be, California law is going to control.
Thank you, Alicia.
Yeah.
Leah, you had a comment?
Oh, no, that was a great question.
Okay, great. So,
Interestingly enough, the salons are the one of the businesses that still employ a lot of independent contractors, and the governor's shutting them down right now. Food for thought.
So I'm going to follow up on that question as to whether or not, like the salons or the gyms, and you have all these sectors of businesses essentially. So is there any legal obligations? And I know that each have their own sort of a criteria to make a safe and healthy workplace. Is there any additional? Is there anything that is required of all businesses to do uniformly to provide this healthy workplace space, as opposed to it's addressed particularly to the type of business it is? Yeah.
Well, I mean, I think we're all governed, whether we're, an employer or going into a store. I mean, there are going to be minimum safety standards that have been issued and directed by the state and in some cases the county for what's required. So you are going to have to continually monitor what those standards are and ensure that you're in compliance with them. And it might be different for, hairdressers versus law firms, or bowling alleys versus Burger King. It's going to be different no matter how, depending on the industry that you're in.
Yeah, so I'm assuming that there's basic wearing of the mask, sanitizers,
Yep.
reasonably accessible, probably, right? So I'm assuming.
Yeah, exactly.
Okay, great, thank you. Thank you.
Mm-hmm.
Any other questions from the participants to the panelists? Okay, so Leah, it's about 3:20, so we still have time if we're going to get some more questions in.
This would be more of a general law question, but what about waivers of liability, kind of an enter at your own risk situation? Is that anything that's going to be defensible?
I mean, waivers are hard to defend a lot of the time. I mean, we do have the assumption of risk defense, but if you do anything to increase someone's risk for injury, then that can result in a waiver of the assumption of risk, even if someone signs a liability waiver to come into a store. And under the circumstances, I don't know, I don't see that practically being enforceable. So in the long run, and I don't know that, for example, even if someone signed a liability waiver to come into a store, for example, and then contracted COVID because no one in the store was wearing masks or social distancing or washing their hands, absent a law like the one that Nevada passed recently where they're providing immunity for it, I don't know that it gets you around that. It's a really great question. I wish I had a better answer for it, but I think it would be a tough sell either direction.
Yeah.
How can we prove that they contracted it at that particular establishment?
I mean, obviously that's going to be a medical expert opinion that's going to be needed to establish that. But, certainly I think, they've been doing a lot of contact tracing. So that might be one mechanism for ferreting out the evidence that you would need to support something like that. But I agree with you that it'd be incredibly difficult unless the person can absolutely prove that they've been nowhere else and around no one else except for going into that store. Then I suppose that might be a way that they could establish that. But again, I think that's going to be, I mean, I never say anything, you know, anything can happen in the law. There are plenty of lawyers out there that will literally take any case, doesn't matter what it is or how absurd it might be, they'll take it because that's just who they are as lawyers. And so I'm not saying it won't happen. I just think it would be unlikely, and it'd be a tough case to establish. You know, not only would you have to establish the breach, but you'd have to establish causation, and then establish the damages that arise from it.
Yeah, if from the waiver standpoint, I think if you were to look at it from the standpoint of, say, a grocery store in a typical slip and fall type case, you could have everyone who comes into the store view or sign a waiver that they're walking in that store at their own risk, and if they slip and fall, that's their own problem. But if the store itself was negligent in not cleaning something up or not being vigilant, then odds are that waiver is essentially going to fall through the cracks, and it will hold no force and effect. What you may only really be doing is deterring some people from possibly trying to litigate the issue. But really, my expectation is that there are going to be sometime next year many different types of forums and gatherings for people who have gotten the coronavirus, and opportunities for attorneys to speak to them just like they do in wage and hour litigation, and try and get people who have contracted the virus and have had to spend money or lose their job or whatever the conditions may be, to bring them in and essentially see if there's a case that they can file. So really, even if you have a waiver, if you're not watching physical distancing at your business or your store or whatever it may be, if you don't have people wearing masks, if you're not sanitizing properly, the waiver is probably going to be of virtually no effect in the long run.
Great, thank you.
So I have another question from the audience participants. There has been a lot of talk about reasonableness. Can Jason or Alex talk about being reasonable with regards to rent relief conversation? What would either side, tenant or landlord, do to help show that they are being reasonable? I also assume that both sides should document their efforts in writing, but just curious to get input on ways either side could show they are being reasonable. James or Alex? Is it Lucker? You have the floor first. Is he here? No? Alex, maybe you can go first.
Okay.
Okay. I think in terms of being reasonable, you know, again, maybe James would have more insight on this, being more his specialty. But I think, as was said, any documentation, I mean, any of this should be either done via email or letter, or followed up with a confirmation email or letter of some kind that you've had discussions about, you know, I missed 6 months of rent. I would like to pay that off over the next 12 months, or however you're going to do that. I think in terms of, you know, the different county or city restrictions, reasonableness is going to be judged based on how long their requirements are. If they only say if they say you have to pay it back within 6 months, that's what's going to be considered reasonable. If they say you have to pay it back within 12, that will probably be what's considered reasonable. So outside of that, it really, you know, as James said, you're not getting a release from paying this rent. You're just getting the opportunity to defer it until you can pay it back.
Yeah, and that's correct. To go off of that, there's the various ordinances that have 6 months to a year. And all the laws required in LA County, state of California, they had their different requirements of you must notify the landlord in writing within 7 days of rent being due. And that was, I believe, the state of California, then some county of Los Angeles had, you must notify within 30 days of rent being due that you were impacted by this. Now, the original requirement was you just had to notify them. You did not have to provide the documentation at that point. So there were the opportunists that took advantage of this, that just sent the form stock letter out that says, I've been impacted by COVID. Furthermore, do not contact me. And in light of all this, we saw the city of Los Angeles pass a law that says, if your tenant reaches out to you and provides you this letter, and they say do not be in contact, and you contact them, they can now sue you, the landlord, in court for up to $15,000 for harassment. So there was all this stuff where people were contacting my office and saying, I have a property in the city of Los Angeles. My tenant hasn't paid me since March. I've requested documentation. They told me they've been impacted, and they will not now respond to me. I've asked for bank statements, or I've asked for employment. I've asked for unemployment records to show that there are unemployed and have been impacted. They're just not providing anything. Unfortunately, with the blanket ban on these prohibitions, nothing can go forward. So I've been advising these clients that I understand they probably do not comply, but they're the opportunists that are taking advantage of this, and they didn't really comply with the law because they were supposed to give you notification within 7 days, and they waited 45 days and sent you this stock form letter. Once this moratorium's over, the reasonableness is for, as Alex said, in Los Angeles County, they have it specific of you have at least a year to pay back if you are a residential owner, or you have a commercial business with 9 or less employees. You have up to a year. You have up to 6 months to pay back if with commercial less than 9 or more than 9 employees. So those are the different reasonableness. So a landlord can't come in and say, I need you to pay me back in 2 months if you're in LA County. Rancho Cucamonga, I don't believe, has any type of requirement as of right now. So that would depend on what is reasonable between the parties. If a landlord is demanding, all right, you owe $30,000 in back rent, I want that paid back in 2 months, and the tenant has come back and said, I could pay that back over a 6 month period, and they start paying, most likely you will not see the landlord file any type of action because now they're starting to pay, and if they remain current and they're paying, they're working off that balance. Part of at least Los Angeles County is also no late fees can be charged during this time. So that was a big thing that was coming up well, all right, now I'm going to charge them late fees and they're owing more. There's no for residential, there's no pass-throughs or late fees that can be added, and that is just another step of all you could charge is the flat rent, no interest, no late fees, no pass-throughs. You can't now charge them utilities, zero payment before. So that is a common thing I've seen of a tenant hasn't paid since March. The landlord is paying utilities, and now they've paid $2,000 in utilities since March. Can I turn off the utilities? No, that is called self-help eviction. You can now be liable as well for that because you are now illegally trying to constructive eviction by turning off utilities, something that you provided. Even though your tenant is in breach of the lease, you have to go through the legal recourse of filing the eviction to get them out, or they will agree to move. So a lot of landlords have tried to work out these approaches, especially since prior to today, it was looking like at least we're 90 days out before any type of action can be filed. It's best to work with your tenants because I say accept any cash you can right now. And when the evictions can start, then we can sit down and look at what's owed, do proper notices. But since really no notices can go out, nothing can be enforced. Work with your tenant right now, and if you come to a signed agreement, great. If your tenant's being not responding, unresponsive, then you can at least have these documentations of emails, text showing you've responded. And when courts open, we can show that they weren't acting in good faith. They just ignored for 5 months without responding to one request by the landlord.
Thank you, James. As a reminder, please make sure that your microphones are off. You're not speaking because you have a lot of background noise. Thank you. Any additional questions as we are about 3:32 now? We're getting a couple more questions in. Leah, do you have some?
Let's see. Oh. It looks like we just have a kind of an end-all question that goes to every one of our panel members.
Yes.
So if there's no other specific actually, we really haven't touched too much on one more question for Alicia. The governor of California came up with the workers' compensation that automatically assumes for essential workers that they have gotten, there we go, COVID from their workplace and therefore are eligible for a workers' compensation claim. Care to comment?
I mean, I don't do the underlying workers' comp claims whatsoever. I handle a very narrow portion of the labor code involving retaliation claims arising from filing a workers' comp claim. But what I would say is, as a matter of course, the Workers' Comp Appeal Board is extremely, extremely employee friendly. And unless you can, as an employer, prove that they did not contract coronavirus from the essential business that you own that stayed operational, then I think that's kind of an uphill battle anyway. I think it's an uphill battle for employers in workers' comp cases anyway. There's just a presumption that if the applicant says, I got this injury at work, then unless you can prove that they were in a car accident the day before, not on work time, you're going to have some challenges concluding that. So again, I mean, one thing that frustrates me as an employment defense attorney in California is I understand why we have some of the laws that we do, and that when they were created and designed to protect certain vulnerable employees or vulnerable components of the workforce, when you tailor a law that narrowly for that protection, you also create opportunities for people to utilize that law to their advantage when it doesn't really apply to them, or it really was never intended to protect them, or just so that they can lie about whatever it is that they want to claim. And so I think this is an attempt, while probably made from a good place, that is going to have long-term effects that are going to be very negative. I mean, I know somebody had a State Farm background up, I think, or a farmer's background up on their screen. I can't see it right now because they've got the spotlight view on me. But, when you make a workers' comp claim, the premiums go up, and they go up pretty substantially because of the way the insurance industry calculates workers' comp premiums and how they get valued and factored. So if a company who maybe prior to coronavirus never had a workers' comp claim because they were a low risk, so therefore they had a low multiplier on their premium, if they now get 1,000 or even 100 workers' comp claims alleging COVID exposure, that employer's premium for their workers' comp insurance is going to go up exponentially. And that's going to have yet another long-standing effect on small businesses and all businesses, quite frankly, and the insurance industry. So I understand that maybe there's some positive background or a good reason, at least in the minds of the people that proposed this legislation and with the governor, but I don't know that it was thought all the way through as to how that was going to affect or impact the economy, the businesses, and the insurance industry.
May I speak to that?
Sure.
This is Marilyn Sparks. farmer's insurance agent, as well as being a Los Angeles County Insurance Commissioner.
Thank you, Leah. So the Workers' Compensation Insurance Rating Bureau is recommending that even though these cases may be compensable, they would not negatively impact the employer as far as workers' comp case count. However, to Alicia's point, overall cost will go up because the estimates for workers' comp related COVID illnesses, they were estimating probably in April, I think the last estimate was about 8 billion. But that's nationwide, not for California, but it's still very high.
I thought you were referring to Los Angeles County.
No. So
Okay, so Alicia, I just had one last question. Is there any science behind if an employee happens to be pregnant and the fear to be essentially if they get COVID could affect the child as well? Is there any science behind that?
I mean, I don't know if there's any science behind it. I'm not, I haven't followed, I don't know that any of the science is accurate today, as accurate as it was yesterday. As far as COVID is concerned, it seems to change every single day. But to go to the fear question, I mean, I think I would go back to the analysis that we discussed earlier this afternoon in terms of is it reasonable, and whether it is or it isn't is going to depend on how it can be accommodated under the circumstances. You know, I know that there are legitimate people, there are a lot of people who are very frightened and very scared about contracting COVID and what that might look like for them and their family. And everyone has a different reason as to why they feel the way they do about it. And I think, again, one thing that we need to try to remember is to, you know, as employers and as lawyers, is to just be somewhat compassionate. You do have a business to run and everyone understands that. But, you know, consider putting yourselves in that person's shoes and what you would want done and how you would want to be treated. And as an employer, I think if you can demonstrate that with sincerity, if you are ever sued, it's going to go a long way to carry the day for you in front of a jury, especially in front of California juries who are, again, much like the WCAB, pro-employee in nearly every single county, and obviously some counties more than others. So.
Thank you. Thank you. So at this time, if we don't have any more questions, I'm going to pass it on to Wendy Lau to do the closing remarks. Wendy.
Sure. First, I just want to say thank you, huge thank you to the attorneys who came on to serve as panelists. I really appreciate your time. I know that even without going to court and not doing in-person depositions and mediations, I know you are all still very, very busy. And for those of you that still have to do the billable hour, which I don't, so happy. But those of you that still have to do the billable hour, I really do appreciate the time that you took for this. And I really hope that today's event is the beginning of some really fruitful partnerships between the city, the university, and our community members, because I really do think that there is tremendous opportunity for us to make each other better by having these discussions and seeing where we can best help each other out, particularly in such a time of confusion and, uncertainty. I think the more that we can brainstorm together to figure out how we can help each other out is going to be hugely beneficial. So, James, I haven't met you, but thank you so much for all of your expertise and time today. It was very enlightening. Thank you, Alex, my friend and fellow ULV alum and Board of Trustee member. I appreciate you taking the time as well. And Alicia, my good old partner in non-crime, from when we used to practice together. So thank you so much. Much appreciated. And to the students who helped to put this together, and to Professor Nakashian and the ULV College of Law and the Chamber. I think this was a fantastic first foray into the possibilities for the future. So thank you. And I hope that, those of you who participated as business owners in the community got something out of this. It may have given you more questions than you thought you wanted or needed, but I always say it's good to know what you don't know so that you can start unraveling what your solutions might be. And I encourage you to spread the word. If you thought this was a good and worthwhile event, please share that. And we can look forward to seeing what else we can do. Thank you.
Thank you. Thanks, everyone.
Oh, thank you. Great. And we did record this. There we go. We did record this, and it will be available. If you request, I can send you a link with a password if you want to be able to view this video at a future time. And Paul, hopefully we will do a follow-up, and especially in light of James's recommendation that next year will be the year of bankruptcy, and possibly do this forum specifically on bankruptcy.
Wonderful. Great. Thank you, everyone.
Thank you.
All right, so this concludes our event today, yes? I'm assuming?
Yes.
All right, thank you, everyone. Thank you for joining. This was awesome. We'll be doing more of these in the future. Great work, everyone.